Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of United States of America versus Matthew Buden. Matthew over here was found in his car with meth. The way that they found his car was by tracking the cell phone of his girlfriend, for which they had a warrant. Matthew over here is sad about being found with the meth by the U.S. government, and he'd like to say that they weren't able to do this because the U.S. government did all kinds of bad things with relation to this warrant. As the U.S. government is going to patiently explain to him, first of all, no, you can't complain about this. And even if you could, we wouldn't be able to dismiss anyway because the police actually followed the law. Let's get started with this. During a narcotics investigation by the Monroe Police Department, multiple drug dealers and cooperating witnesses identified Buden and Davis as their suppliers. One witness informed the police that Officer Heckard that Buden and Davis were planning to drive from Houston to Monroe with 4 pounds of meth. So they're going on a meth-based road trip together. How fun. The witnesses then called Davis on her cell phone to arrange the meth deal, and the police listened in. So this is the tale of star-crossed lovers indeed. Bonnie and Clyde over here. So Bonnie and Clyde over here are involved in the meth trade, and they're going on a romantic getaway on a cross-country tour by car to be able to deliver meth. Unfortunately for their plans, they've been discovered as part of a conspiracy to distribute drugs, and the police are wise to them. So the police listen in on this phone call, and they arrange the meth to be delivered. And now they're on the road, and now they're going to go arrest them. Fantastic. The police used that information and Davis's cell phone number to request a search warrant. In the warrant application, Heckard asked for the GPS coordinates of the cell phone over the next 16 hours. So it's like, we would like the GPS coordinates for this cell phone, please. And of course, the court says, yeah, that sounds like probable cause to me. Why do you think they're involved in the meth trade? Because of the phone call, I overheard them discussing the meth trade. Okay, that sounds like probable cause. During the road trip, alas, they didn't quite make it all the way to the destination. The police officers eventually stopped the car, searched it, and found the meth that they were looking for. They then arrested Davis and Buden and recovered Davis's phone from her purse. So the police have gotten the search warrant for the GPS location. They followed them along the way. They picked a particular location to arrest them at, and the road trip was not to be. So Buden and girlfriend are arrested, and their 4 pounds of meth is no more. But of course, he's sad. He's sad that he being arrested for the 4 pounds of meth. He'd prefer not to go to federal prison. So he's going to try to say this search was improper. Every lawyer in the room knows right away this is not going anywhere. For the simple reason was it wasn't his cell phone. So that's kind of the end of that game, but we'll learn why. Buden argues that the police violated the Fourth Amendment by obtaining the GPS coordinates via a defective warrant. Just no. Just no. There's nothing wrong with this warrant, and it wasn't for your property. So just all the no. But, I guess you gotta try something. The history of how the Fourth Amendment came to be does matter. The history explains the Fourth Amendment requirement for specific warrants. It says that unreasonable searches and seizures are forbidden, and it suggests remedies for violation of those rights. Of course, the complexities of history sometimes leave room for debate in answering questions, but one thing is not debatable. The Fourth Amendment is not a weapon that uninjured parties get to wield on behalf of others. As with the common law that preceded it, the Fourth Amendment protects individual security in, and these would be the key words, so pay attention, in their persons, in their houses, their papers, and their effects. It does not, and never has, since it came up with the concept, protected an individual's right of secrecy or security in other people's stuff. So right away, no, just all the no. The Fourth Amendment does not apply to you because it wasn't your cell phone. So that's not going to fly. This has never been held. So you cannot invoke the rights of others. That was an invalid search. Was it a search against your property or papers? No. Then literally no one cares. Also, it wasn't an improper search. We'll get to that later. But even if it was, we just don't care. Here, the parties agree that the government conducted a search when it used the GPS coordinates from Verizon to locate the phone. But the district court held that Buden over here lacked standing to challenge the search and seizure and denied his suppression motion accordingly. There's no standing. No. To determine whether he has standing, we first identify the place or thing that was searched. The warrant authorized the police to search the following: GPS coordinates and registered owner information of a cell phone number, which ends with 0889. So if your phone number ends in 0889, congratulations, I suppose. By the way, they're just blocking it out. It's not literally every number 0889. I was just trying to make a joke. Don't panic. This is to include location from current date and time of August the 15th, 2017, from some time to some other time. Cell phone number, blah, is activated through Verizon Wireless and is currently being used by Jessica Nicole Davis, our Bonnie to our Clyde miscreants. Thus, the government sought, and Judge Jefferson granted 16 hours of access to the GPS coordinates of the phone. Nothing in the record or the brief suggested that the police officers ever exceeded the scope of that warrant. So they were within the time bounds. They got the phone, that number for that location for that time. They never exceeded that. What is your problem exactly? Here's our problem, apparently. Buden would like us to go further. Okay, let's see if we want to go further to protect him. In his view, the government extended beyond Davis and her phone to include Buden and the car in which he and Davis were traveling. Ooh, they were tracking me and my car, not just merely the cell phone. Ah, that is so, he argues, because the purpose of the search warrant was to track the movements of the car by using the GPS location of the cell phone inside the car. That argument fails for two reasons. Okay. Just all the no. Just all the no. There was a case, and the court is going to get to it later, called Carpenter, which dealt with the police putting a GPS locator on your car. They can't do that without a warrant. You know what they can do? They can listen to the bug that you bring into the car yourself. You know, they don't have to plant the bug when you just bring it into the car because it's your phone. And yeah, they were tracking your car using the bug that you conveniently provided to them. How thoughtful. Having concluded that the place searched is located to information about Davis and the cell phone, we ask whether Buden has a Fourth Amendment property or privacy interest in that information. Not so much, no. The Supreme Court requires us to consider whether the person claiming the constitutional right has a legitimate expectation of privacy in the premises searched. Do you have a legitimate expectation of privacy in someone else's cell phone? No. Privacy and property concepts are often linked because one who owns or lawfully possesses or controls property will in all likelihood have a legitimate expectation of privacy by the virtue of the right to exclude, which isn't you. It's not your phone. That is why we must remain ever mindful of the Fourth Amendment and its property-based history. Buden directs us to five critical facts that will definitely cause us to think about this differently. Let's think about what these 5 facts are and why they definitely changed the picture for sure. 1, he purchased the phone and he gave it to Davis. Ooh, he purchased it. 2, he had permission to use the phone. Whoa, he had password access to the phone. He accessed his Facebook account from the phone, and he used the phone to capture intimate videos of him and Davis, which I'm sure were very entertaining, to be sure. However, fact number 1 is irrelevant. You bought the phone. You know why it doesn't matter? Because you abandoned the property. It wasn't yours. You may have bought it. It was your phone when you bought it. You know what you then did? You then abandoned it because you gave it to someone else and it became their property. Deep thoughts. Is not yours anymore. Wow. The government also correctly observes that fact number 3 about the password is not supported by the record. Davis testified only that Buden had put in her screen name and password while logging into Facebook, not while accessing the phone more generally. Facts 2, 4, and 5, including the sexy time videos, reduce a claim that Buden sometimes used his phone for very personal activities, as it turns out. There's no indication that Buden ever used or possessed the phone outside of Davis's presence, however, and the record doesn't tell us how often he accessed Facebook or captured intimate videos. Nice. What the record does tell us is that Davis was the primary user. The Supreme Court's prior case of Carpenter versus United States, where the government got busted by the Supreme Court by planting a GPS bug on someone's car, thus violating their property rights, does not change the result. You know why it doesn't change the results? Because the police didn't plant a GPS device on your car. You know who did that? That would be you. You would be the one who did that. You're the one who planted the GPS device on your car. Good work. Because the record reveals a cell phone's location history, and because a cell phone faithfully follows its owner, well, debatable, but whatever, the court held that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through that device location. However, the pronoun is important. So, the court acknowledges that pronouns are important, I suppose. So if all the people said, what is your chosen pronouns? Well, pronouns matter, at least when we're trying to figure out whose rights are involved. So these pronoun rights matter, I suppose. So the pronoun in the Supreme Court's holding is important. Yes, it is. Carpenter did not address the question of whether an individual maintains a legitimate expectation of privacy in a record that reveals someone else's location. Right. That would be weird. No, they definitely didn't speak to records that talk about someone else. It's just you, and no, not just now. Even if Buden has standing to challenge the GPS search, he must also show the search was unreasonable. That's going to be kind of hard. The police had a pretty good reason for what they got, yeah. It is beyond dispute that the police began tracking the GPS coordinates only after they received the warrant, like good police. And Buden contends the warrant was supported by probable cause with regard to his illegal drug activities. That would be, yes. That fact makes it easy. Yeah, we got the warrant because of the drugs. And we used the warrant to track you, like the warrant said we could. Kind of easy, yeah. Buden nevertheless claims for the first time on appeal, which always just thrills the court when you try to do that the GPS search was unreasonable because the authorizing warrant failed to comply with the Stored Communications Act. I have to admire this on some level. You just really are trying and reaching for the stars. You know why the warrant was invalid? Because it violated federal law. It violated the Stored Communications Act. Sure it did. Well, the court is going to explain to you in very small, easy to understand words. No, not so much. But, nice try, I guess. So, just keep reaching for those diamonds. Maybe you'll get them eventually. The Secured Communications Act creates various mechanisms by which a governmental entity may require a provider of an electronic communication service, such as Verizon here, to disclose a record or other information pertaining to a subscriber or a customer of such a service. And here would be the critical part for you, Buden, so pay attention. One such mechanism allows the government to obtain a warrant from a state court of competent jurisdiction using state warrant procedures. And that is exactly what they happened here. So you know why it didn't violate the Stored Communications Act? You know why it didn't violate the Stored Communications Act? Because the Stored Communications Act says that a state court of competent jurisdiction can issue a search warrant, and it's okay. So, no. And there is no indication that the police officer or the judge violated the state warrant procedures, which seems very unlikely indeed. So the warrant clearly complies with the plain text of the Stored Communications Act, but nice try anyway. Buden disagrees. Aw, he's sad. He's sad. He doesn't like the court's reading of the Stored Communication Act. He doesn't like the fact that they can get access with the warrant. He's sad. Okay, let's talk a little bit more about his sadness. He contends the Stored Communications Act requires the government to produce probable cause that the subscriber or the customer committed the crime. So you can't get a warrant for this cell phone because you had to have probable cause that the subscriber or customer of the phone did a bad thing. And you didn't have that, even though he kind of did, but let's look past that. And because Davis's parents were the relevant Verizon subscribers, it was my parents who owned the phone. It was their account. Nice leeching on their account, by the way. Buden insists that the Stored Communication Act evaluates a warrant premised on a legal activities not involving Davis's parents. Oh, it's her parents, by the way, not his parents. Yeah, so Bonnie and Clyde here cannot afford their own cell phone bill. That's hilarious. So Bonnie over here has her parents paying the Verizon bill. I wonder how they feel about that now. And so Buden over here says, you need information that would implicate the parents of my girlfriend. Way to throw them under the bus. That's just fantastic. That's great. This argument borders on the frivolous because, of course, it does. The law merely requires that a warrant comply with, as relevant here, state warrant procedures. Yep. And subsection D authorizes the disclosure of otherwise protected information upon a showing that there are reasonable grounds to believe the information sought is relevant and material to an ongoing criminal investigation. Any investigation. Any investigation would be fine. If the records that we need are someone else's records for some reason, as long as they're relevant, we have probable cause and all the rest of it, that's fine, not a problem. The stored communication argument fails for another reason. Suppression is not a remedy for a violation of this law. Congress could not have been clearer, so Congress said no, not so much. The law says the remedies and sanctions described in this chapter are the only judicial remedies and sanctions for non-constitutional violations of this chapter. So even assuming they violated, which they didn't, this is not a valid remedy. Someone asked, didn't the guy get busted straight up with meth in the car prior to Verizon records being pulled? No, they had a search warrant for the GPS locations. So the cops talked to Verizon to get that information. That's how they got it. The record shows that the police called Verizon 6 times for information on the GPS location. So that's how they got it. Thus, that brings us to the end of our discussion of the case of United States of America versus Matthew Buda. In this case, Bonnie and Clyde were going on a road trip to deliver 4 pounds of meth, but it was not to be, because the police knew about their activities from phone calls and informants. And they got a valid search warrant to track the girlfriend's phone. And then they did that. And then they arrested them, and Matthew over here is sad about that. And the court has to patiently explain to him, it wasn't your cell phone, it wasn't your rights being violated. Even if they were, this was a valid warrant, they acted within it, and all your Stored Communications Act arguments, what are you even talking about? No, they had a valid search warrant, so none of that works. So Matthew will have to enjoy jail, and that brings us to the end of the discussion of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.